Chapter 15, Formation and Performance of Sales and Lease Contracts, presented by Kelly Herzik. Up until now, we've mostly discussed contract law under the common law, though contracts are also governed by state statutory law and the UCC. Federal law rarely regulates contracts, and when it does, it is usually in a specialized area like stock sales. While we have touched on a few aspects of the Uniform Commercial Code, we are now going to review it in detail in the next few chapters. Chapter 15 introduces the UCC, Articles 2 and 2A, which govern sales and lease contracts. We will focus on the UCC and its scope, including an introduction to sales and lease contracts and how they are formed and executed. In this lesson, we're going to discuss the Uniform Commercial Code, Articles 2 and 2A of the UCC, contracts for the international sale of goods, contract formation under the UCC, title, acquiring good title, types of sales contracts, and risk of loss during a breach of contract. We will begin with a reminder on the background of the UCC. The UCC, when it was originally drafted in 1952, was a scholarly work that had a goal of standardizing commercial transactions, primarily those in interstate commerce. As you might remember, all 50 states, most U.S. territories, and the District of Columbia have adopted the UCC with minor revisions, though Louisiana and Puerto Rico have not adopted Articles 2 and 2A concerning sales and leases. The UCC, as adopted by the states and territories, becomes part of each state's statutory law. And remember that the goal of the UCC was to harmonize and standardize the law of sales and commercial transactions in the U.S. It established a framework of expected rules for sales and commercial transactions based in part on long-held commercial expectations. We talked about that in Chapter 2. The UCC has long met its goal of standardizing and clarifying state laws concerning sales and commercial transactions in interstate commerce. Basically, the UCC makes it easier for business and individuals to enter into commercial transactions in more than one state. It facilitates many, but not all, commercial transactions. Judges like precedent, as we discussed before, and the UCC, since it is nearly 70 years old now, has built up a significant amount of legal interpretation in the courts. Judges generally try to interpret the UCC to keep an agreement in force unless there is malfeasance during the contract's formation or performance, basically if one performing party is performing badly. While the UCC has a wide reach in commercial transaction, it does not govern all commercial transactions. Take a look at Exhibit 15.1 in your book. You can see that the UCC is divided into 9 articles, but based on the topics, you can also see that the UCC only governs certain areas in business transactions. In this particular block of classes, we will discuss Articles 2, 2A, 3, and 9. We will begin with Articles 2 and 2A of the UCC. Remember that Articles 2 and 2A have not been passed in Louisiana or Puerto Rico. So if you are doing business in Louisiana or Puerto Rico, you will need to check those states or that territory's statutory or common law for formation and contract interpretation rules. For sales, the UCC divides all items for sale into 3 categories: goods, realty, and services. This includes intangible goods such as securities. Intangible goods are not goods. They're actually services. Article 2 of the UCC governs sales contracts for the sale of goods. Article 2A governs lease contracts for the lease of goods. Most often, Articles 2 and 2A mirror each other, and unless there is a difference that I point out, assume that the rule applies equally to 2 and 2A for both sales and lease contracts. While the UCC has a broad body of case law attached to it, it does not govern every sales contract. When the UCC is silent on an issue of sales contract formation or interpretation, a state's statutory or common law rules apply. Just like in Louisiana and Puerto Rico, you have to look to their state law for formation or interpretation rules. The UCC treats merchants differently than regular buyers and sellers. Merchants are held to a higher standard of care and behavior than non-merchants. Do not assume that because it is a business name that it must be a merchant. We will see the differences in later slides. Now, because it was first drafted in 1952, the UCC does not answer many issues in relation to e-commerce, such as internet information and software sales. Another, newer uniform code was drafted called the Uniform Commercial Information Transaction Act, which was designed to address these areas. However, it has faced significant opposition, and it has only passed in 2 states, Maryland and Virginia. So even for information on the internet and software, we're still primarily dealing with the UCC, except in Maryland and Virginia. First, we'll discuss Article 2 of the UCC. What is a sales contract under the UCC? Well, let's break it down. A sale under the UCC, Section 2-106, consists of passing title from the seller to the buyer for a price. Goods are defined in the UCC, Section 2-105, as all tangible things which are movable at the time of identification to the contract for sale. The key words there are tangible and movable. A sales contract would be the purchase of goods where title to the goods passes from the seller to the buyer. Now, services, including intangible goods and real estate, are not included in the definition of goods. The UCC classifies these generally as non-goods, and their sale is governed by the common law and/or statutory law in the states. Remember that for goods to be tangible, they must physically exist. Corporate stocks or bonds are intangible goods, and therefore they're not goods under the UCC. Just remember that if the word intangible appears, it basically equals service. Neither is real estate, since it is not movable, though items removed from the real estate such as crops, oil, minerals, and soil are goods. Here's the key. Services are movable but not tangible, so they cannot meet the UCC definition of goods. Real estate is tangible but not movable, so it also is not a good under the UCC. Now, if the contract is a mixed sales contract for the sale of goods and non-goods, and the predominant purpose of the contract is the sale of goods, then the UCC applies. An example of this would be the sale of furniture and its delivery and setup. Furniture is obviously a good under the UCC, but delivery of the furniture and setting it up in the buyer's home is a service. Now, this is truly a mixed sales contract. In this instance, the predominant purpose is the sale of the furniture, and the delivery and setup are incidental to the furniture purpose. Buying the furniture is the real goal of the contract. No one is going to buy the service of delivery and setup of furniture without first buying the furniture. Therefore, this type of mixed sales contract would be subject to the UCC. Now we'll discuss merchants, which is a term of art under the UCC. The UCC has special provisions that apply only to merchants, and the UCC imposes greater duties on merchants. So what is a merchant? A merchant is defined as a person who regularly sells goods as his or her business or trade, or employs people to sell those goods. It's anyone who works for a person selling goods, or anyone who holds himself or herself out as a merchant or dealer. The UCC assumes that merchants have a greater ability to protect themselves in commercial transactions than do the ordinary buyer or seller. The ordinary buyer or seller are generally referred to as consumers, and businesses, as long as they don't sell goods of the particular type at issue, are also considered consumers. Next, we'll discuss Article 2A of the UCC. Remember, this too is not passed in Louisiana or Puerto Rico. Article 2A covers contracts for the lease of goods, but not the lease of real property. Remember, if it's a lease concerning land or real property, you know Article 2A does not apply. This section of the UCC has become more relevant as individual and business consumers are leasing more goods than ever before. Remember that both individuals and businesses can be classified as consumers as long as they do not meet the definition of merchant. Consumers lease cars, cell phones, iPhone Forever plan, my niece has one, equipment and machines. You may even have leased your textbook. It was an option. For example, the cell phone company, who is the lessor, transfers the right to possession and use of a cell phone, a good, to you as lessee for a set period of time and for consideration, which is money. UCC Section 2A-103 defines a lease as a transfer of the right to possession and use of goods for a term in return for consideration. Remember the example I just gave you about the cell phone company who is the lessor. A lessor is a person who transfers the right of possession and use of goods under the UCC lease. A lessee is a person who acquires the right to possession and use of the goods under a lease. It's very important to remember that the lessor retains title to the goods leased. He only rents out the goods for a set period of time and for consideration, but he is still the owner of the goods. Our next topic is contracts for the sale of international sale of goods. Due to the increasing global markets, in 1980, the United Nations Convention on Contracts for the International Sale of Goods, the CISG, was offered as a treaty that countries could sign. This is also known as the Vienna Convention. By signing this treaty, countries indicated their willingness to allow this treaty to govern international business-to-business sales contracts. Currently, 93 countries, known as contracting states, including the United States, have ratified the CISG. In international sales cases, the CISG, as a federal treaty, preempts the UCC as state law. You might remember the concept of preemption from our earlier lesson. There are differences between the CISG and the UCC. Those are summarized well in Exhibit 15-4 on page 309 of your textbooks. Now, one of the biggest differences between the CISG and the UCC is that the CISG does not govern consumer contracts. It only governs business-to-business contracts. If you know that, and if you know the main differences from Exhibit 15-4, you will do fine for testing purposes. Next, we'll discuss contract formation under the UCC. While there are many similarities between the UCC and the common law concerning contract formation, there are some key UCC provisions that govern sale and lease contracts that differ from the common law. Under both the UCC and the CISG, contracts for the sale or lease of goods may be made in any manner sufficient to show agreement. It's much easier to show the formation of a contract under the UCC and the CISG than the common law. Courts generally uphold UCC contracts as long as the court can determine that the parties intended to make a contract and there is a reasonably certain basis upon which to fashion a remedy. Under the UCC, the focus is on offer, acceptance, and consideration in contract formation. We talked about the other elements like mutuality and legality. The UCC focuses generally on offer, acceptance, and consideration. Courts also have to contend with something called the battle of the forms between parties to determine a contract's actual terms. As we discussed in the previous slide, the UCC tends to focus on offer, acceptance, and consideration. So let's start with offer. Under the UCC, certain terms can be left open and filled in later. This doesn't happen under the common law because remember we have the mirror image rules. You have to accept the offer's terms as they're written. Well, if there's not enough terms and terms are uncertain, then you have no effective offer. But under the UCC, you can leave out price. If price is left off, you can put in a reasonable price is supplied at the time of the delivery of goods. Whatever the goods market value that day would be a reasonable price. Payment can be left out. And if there's no payment term, payment is then generally due at the time and place the buyer is to receive the goods. Delivery, if that's missing, then the place for delivery is the seller's place of business. Time can be missing, so that means then the contract just can be performed in a reasonable time. Duration, the party that wants to terminate an ongoing contract must use good faith and give reasonable notice. There doesn't even have to be a term of duration. However, as we've discussed in previous lessons, quantity is a required term under the UCC. Without it, courts generally have no basis for a remedy. There are two exceptions. There's always an exception. The UCC does allow for what they call output or requirement terms in lieu of a number quantity. For example, a farmer may agree to sell all the yield of his wheat crop to a buyer without knowing the exact amount. This is an output contract and is enforceable under the UCC even though the exact quantity of goods is not specified. Likewise, a buyer may buy all the stock of a certain item without knowing the exact amount the seller has in its warehouse. This is a requirement contract and it generally translates to, I'll take all you have. Then there are firm offers under the UCC 2205. And this is offers made by merchants, not consumers, just by merchants, are firm offers if the offer is made in writing and it gives assurances that it will be irrevocable for up to 3 months despite a lack of consideration for the irrevocability. That's an option contract. And remember, under the common law, you have to have consideration for option contracts. Firm offers differ from the common law. Under the common law, offers are revocable until acceptance unless there is an option contract with consideration for the option in place. Under the UCC, options for up to 3 months made by a merchant, not a consumer, do not require additional consideration. The next element of contract formation that the UCC focuses on is acceptance. Under the UCC, acceptance may be made by any reasonable means and is effective when dispatched, when sent. The common law rule known as the mirror image rule, which requires the acceptance to mirror the terms of the offer or no contract is formed, does not apply under the UCC. Recall that the mirror image rule requires a party to accept all the terms as offered. Otherwise, if the acceptance is not on the exact terms as the offer, the acceptance is not valid and no contract is formed. Instead, the offer is deemed rejected and the acceptance with new or different terms is treated as a counteroffer. That doesn't happen under the UCC. Instead, under the UCC, additional terms are permitted in contracts for the sale or lease of goods. Under the UCC Section 2-207, additional terms do not negate acceptance unless acceptance is made expressly conditional on assent to the additional terms. The additional terms are treated as proposals for addition to the contract. Between merchants, the additional terms become part of the contract unless the offer expressly limits acceptance to the terms of the offer, the terms materially alter it, or notification of objection to them has already been given or is given within a reasonable time after notice of them is received. Basically, under the UCC, even if the terms don't match for offer and acceptance, acceptance is still created. You still have offer and acceptance, and then those additional terms just become proposals, but you still have a contract. The final element that the UCC tends to focus on for contract formation is consideration. Just like the common law, sale and lease contracts under the UCC require consideration. Under the common law, contract modifications also require consideration for the modification to be enforceable. We've discussed contract modifications before, particularly in light of construction contracts. However, unlike the common law, sale and lease contract modifications do not need new consideration to be enforceable under the UCC. The UCC requires only that modifications must be made in good faith. That's very important. If the contract falls within the statute of frauds, or if the contract as modified is governed by the statute of frauds, it must meet the requirements of the statute of frauds as well. So the statute of frauds still does exist under the UCC, and you still have to pay attention to it. As I mentioned a few slides ago when talking about contract formation in general, courts have to contend with the battle of the forms between parties to determine a contract's actual terms. As I'm sure you've seen, many contracts forms have what they call boilerplate terms, often also known as the fine print, in their written documents. A battle of the forms often occurs when parties are negotiating and offers and counteroffers are being exchanged in writing. Parties often submit their own form to the other party with an offer, and the other party will often respond to the offer on their own form. These forms often contain different terms. Because under the UCC, additional terms do not negate acceptance, if the last set of form contract terms is not specifically rejected, then the last term standing, the last form, the last ones submitted are the ones applicable to the final transaction. So if a company submits their offer and the other person submits a counteroffer that's then accepted, the other person's form wins. The UCC is structured with the goal of facilitating commercial transactions. So it assumes that the terms found in the battle of the forms are part of the contract, whether expressly agreed to by the parties or not. So you have to be very careful when forms are being exchanged. Now, the CISG is different, and it follows the common law mirror image rule generally. If the parties did not expressly agree to certain terms, then those terms are not assumed as part of the contract, unlike under the UCC. Next, we'll discuss the statute of frauds in the UCC. Under the UCC, contracts for the sale of goods over $500 must be in writing. You've seen this one before. But leases of goods that require payments of $1,000 or more must also be in writing. The UCC and the common law rules differ on what constitutes a sufficient writing for the contract to be enforceable. A writing is a document or documents taken together that show contractual intent and satisfy the statute of frauds requirements. The common law requires a writing created or signed by the party who is contesting the enforceability of the contract, usually the defendant in a breach of contract case. Now, this is also true of the UCC unless the parties are merchants. Remember, merchants have special provisions that govern them. If the parties are merchants and have an oral agreement for the sale or lease of goods, then there only needs to be a written memo of understanding on the transaction from either party to the other to satisfy the writing requirement under the statute of frauds. The other merchant does not need to acknowledge the memo for it to be sufficient. And if the memo is not objected to within 10 days of receipt, the oral agreement memorialized by the memo is binding. Now, the CSIG has eliminated the statute of frauds altogether. The CSIG requires only credible and reasonable proof that a contract exists. Next, we'll revisit unconscionability and how it interacts with the UCC. A contract or contract clause is unconscionable if it is so one-sided, so unfair that a court would be unreasonable to enforce it. As we discussed before with the common law, unconscionability tends to be a sliding scale. The more unfair it is, the more likely the court will invalidate the entire contract. Generally, if a provision is unconscionable and goes to the heart of the contract, i.e., it's the main purpose of the contract, the entire contract is usually invalidated. If it's only a provision in an otherwise generally fair contract that is unconscionable, Courts will more likely strike that clause and enforce the remainder or interpret the contract terms in a way that prevents an unconscionable result. This is the same as the UCC. The UCC specifically addresses unconscionable contracts in sections 2-302 and 2A-108. If a court holds as a matter of law that a contract for the sale or lease of goods is unconscionable, it may either refuse to enforce the contract as a whole. Remember, the more unfair it gets, and if it goes to the heart of the contract, the more likely the entire contract will be invalidated. Or a court may strike the unconscionable clauses and enforce the remainder of the contract. Finally, it may limit the application of any unconscionable clause as to avoid any unconscionable result. So as you can see here, the UCC and the common law are pretty much similar. Well, once the contract is formed and the parties are obligated to perform under the UCC, the next issue to be considered is title of the goods. Title simply means ownership. The most important issue with title is that to provide good title to goods, a person must have title to goods in the first place. You cannot get good title from a thief. If you remember nothing else about title, remember that you cannot get good title from a thief. To be able to sell goods, give them away as a gift, or pledge them as collateral for a loan, you have to own them. You cannot sell, gift, or pledge something you do not own. Now, there are three kinds of title we're going to discuss. Good title, title acquired from someone who owns the goods free and clear. Void title, title that is not true title at all, like purchasing stolen goods knowingly or even unknowingly results in void title. And then there is the third option, which is called voidable title. This occurs in some situations where the original sales contract is void, but the goods have already been sold to a third party. How do you acquire good title? The most obvious and safest way to obtain good title to goods is through a purchase from someone who owns the goods free and clear without any qualifications. This means the goods don't have a mortgage on them, they don't have a lien on them. The people own them outright. Someone who has possession of stolen property does not have good title and can never pass good title. They have void title. So in a testing situation, if a thief is in the chain of title, you know void title is being passed. Good faith is irrelevant when passing void title. Even if you've unknowingly bought stolen goods and try to sell them, you're still conveying void title, even if you did that in good faith. No matter how honorable a person is, if they have void title, they can only pass void title to a buyer. So, on a question that deals with is title good, look and see if there is a thief in the chain. There is only one exception to passing void title, an entrustment situation, and we will discuss that later. The last type of title is voidable title. In most sales, when a seller transfers the goods to the buyer in exchange for consideration, i.e. money, the buyer gets good title to the items purchased. However, a buyer gets only voidable title if any of the following apply. The buyer deceived the seller regarding his or her true identity. The buyer wrote a bad check or other payment failure for the goods. For example, if there is a failure of a transfer of funds. The buyer committed criminal fraud in securing the goods. The buyer and seller agree that title will not pass until some later time, such as rent to own. Or 5, the buyer is a minor. Now you may be asking, what about those who are mentally incompetent? We talked a lot about that under the common law and talked about voidable contracts. That's trickier for sellers. As you may recall, someone can have a mental impairment but still be able to enter into a binding contract as long as they understand the terms and conditions in the contract. If the person is mentally incompetent but has not yet been adjudicated by a court as mentally incompetent, i.e. there's no order, but they do not understand the terms of the contract, then the contract is voidable by the person with the mental impairment once they recover. Lastly, if the person has been adjudicated to be incompetent by a court of law, then any contract they enter into is void because only a guardian can enter into contracts on their behalf once a court has determined them to be mentally incompetent. A seller who finds out someone has a mental defect should do his or her due diligence before trying to reclaim title to goods under these scenarios. Now, the first 4 items in the list above come from actually the UCC, and the last one, the buyer is a minor, comes from the common law, just like mental incapacity does. A seller who discovered any of these may cancel the contract and reclaim title to the goods, even if they have already been delivered to the buyer. This is voidable title. Next, we'll discuss entrustment. This is the exception to the passing of void title that I mentioned previously. Entrustment involves the transfer of goods to a merchant who ordinarily deals in that type of goods. If a person entrusts a merchant who deals in that type of goods, the merchant can transfer all rights to the goods to a buyer in the ordinary course of business. In an entrustment situation, the good faith third-party purchaser for value gets good title to the goods he or she purchases from the merchant, even though the merchant doesn't have actual title. They're transferring something they do not own. A good faith purchaser for value is someone who buys an item in good faith from a merchant who sells those types of goods, does not know the item belongs to another party and not the merchant, and pays a fair market value for the item, not an unreasonably discounted value. You can't be a good faith purchaser for value if you're buying something at a huge discount. That's kind of in the category of too good to be true. In this situation, the good faith purchaser for value gets good title to the goods, and the original owner who entrusted the goods to the merchant can't recover them. They can't get back good title. The original owner's only recourse is to sue the merchant. Let me give you an example. Suppose you take your car to the dealership for routine service. After the service is performed, the car is accidentally parked in the used car area and sold to a third party for fair market value. As long as the purchaser is considered a good faith purchaser for value, you cannot recover the car from them as good title passes to that buyer. Your only recourse is to sue the car dealership. Another example is pawning a piece of jewelry at a pawn shop that routinely sells used jewelry. The pawn shop is supposed to hold the jewelry for a certain amount of time so you can come and collect the item and repay the agreed upon amount to do so. However, the pawn shop sells the jewelry immediately to a good faith purchaser for value, you cannot recover the jewelry. You have to sue the pawn shop owner for breach of contract. Next, we'll discuss title versus other interests in goods. Under the UCC, there are several issues concerning title that are broken up and treated separately. There's ownership. We have to ask, when does title actually transfer from the seller to the buyer, since the right to transfer ownership of the goods is tied to title? Then there is encumbrance. The right to encumber goods as collateral for a loan depends on who is holding title to the goods. Having title means that one can pass title and encumber title. Then there is loss. The right of indemnification for the loss of or damage to goods is examined based on when the risk of loss attaches prior to the buyer taking complete possession of the goods. Then there is insurable interest. This is the right to insure the goods against risk of loss or damage. Both the buyer and the seller have rights to insure the goods at certain points in the transaction. Now, the parties can always determine these issues in their contract and allocate risk of loss and the right to insure the goods accordingly. The UCC rules are the default position when the contract is silent as to these issues. We will review these issues as we discuss the types of sales contracts next. Next, we're going to discuss the types of sales contracts generally. There are 4 broad categories of sale of goods contracts under the UCC. There is a simple delivery contract. This occurs when the purchase of goods are transferred to the buyer from the seller at the time of sales or another later time by the seller's delivery of the goods. Then there's common carrier delivery contract. This occurs when the goods are delivered to the buyer by a common carrier such as UPS or FedEx. Then there are goods embailment contract. This occurs when the purchased goods are in some kind of storage under contract with a third party, such as in a third-party warehouse. Finally, there are conditional sales contracts. These occur when the sale itself is contingent on approval of the goods. First, we'll discuss a simple delivery contract. Typically, with this type of UCC contract, the buyer and the seller agree to a contract, the buyer pays, and then leaves with the goods. That's the most straightforward contract under the UCC. Title to the goods passes to the buyer when the goods are identified in the contract, when the contract is executed. The risk of loss transfers to the buyer when the buyer takes possession of the goods. The seller can insure the goods until the buyer takes possession. Now, an insurable interest is created in the buyer when the goods are identified in the contract, meaning at the same time title passes to the buyer. At this point, the buyer can purchase insurance to protect against risk of loss because they have title. So at that point, before the goods are transferred to the buyer and the seller still has possession, both parties theoretically can buy insurance over the goods. Now, if the buyer comes back to pick up the goods later or has them delivered later, title and insurable interest are the same as when the buyer takes goods away immediately. If the seller is a merchant, the risk of loss remains with the seller until the goods are delivered. But if the seller is not a merchant, if the seller is a consumer, the risk of loss is on the buyer under the tender of delivery rule, meaning the risk of loss is on the buyer at the time of the contract execution. Tender of delivery is the moment the goods are available for the buyer to take. If goods are destroyed, once they become available for the buyer to take, and as long as the seller is not a merchant, the buyer bears the risk of loss if he or she leaves and decides to come back later to pick up the goods. For example, suppose you buy a piece of furniture at a garage sale, pay for it, and leave to get a truck to bring it home. If there is an accident and a third party destroys the furniture before you can return to pick it up, the seller is not under any obligation to return your money because the risk of loss is on you as the buyer. However, if the seller is at fault and destroys the furniture, you would have tort remedies for the destruction of the furniture by the seller, but you wouldn't be able to sue them necessarily in breach of contract because you assumed the risk of loss of the furniture. Next, we'll discuss common carrier delivery contracts. Common carriers can be trucking companies, airlines, train companies. Any public or private entity that transports people or goods for a fee is a common carrier generally. FedEx, the United States Postal Service, and UPS are all common carriers. In this type of contract, the buyer and seller enter into a contract for the sale of goods, and the seller then places the goods with a third-party common carrier for delivery to the buyer. The common carrier is an independent contractor to the seller and not an agent of the seller. If you'll recall during our discussions in torts, this means that the seller is not liable for the torts of the common carrier because the common carrier is an independent contractor who the seller does not control and who is not an agent of the seller. There are two types of these contracts: shipment or origin contracts and destination contracts. Shipment contracts require the seller to ship goods to the buyer by common carrier. Shipment contracts don't require the seller to ship to a particular destination, just say Chicago, Illinois. The seller deposits the goods with the common carrier and notifies the buyer of the shipment. Then they give the buyer documentation of ownership so that the buyer can go and pick the goods up when they arrive by train in Chicago. Title vests in the buyer at the time of shipment, so the buyer bears the risk of loss during shipment for these types of contracts. Then there are destination contracts. These are far more common. Destination contracts requires the seller to deliver the goods to a destination stipulated in the sales contract, a specific address. Title does not pass until delivery, so the seller bears the risk until delivery. An insurable interest is created when the buyer and/or seller hold title or has a risk of loss. The last type of sales contracts under the UCC are known as conditional sales contracts. There are two types of conditional sales contracts: sales on approval and sale or return contracts. A sale on approval contract allows a buyer to take possession of the goods before deciding to complete the contract and make the purchase. An example would be a person being allowed to take a car home overnight for an extended test drive. You get to decide whether or not you like the car for a longer period of time than just the 20 minutes of the usual test drive. That's taking the car on approval. Title and risk of loss remain with the seller in these approval contracts. A sale or return contract occurs when the seller and buyer agree that the buyer may return the goods at a later time. These type of contracts often relate to inventory sales, and an insurable interest is created in the buyer once the goods are identified in the contract, once the contract is signed. Title and risk of loss depend on whether the goods are in bailment, delivered by common carrier, or delivered by the seller. For example, a fashion wholesaler sells clothes to a buyer who buys dresses for her store. If the dresses do not sell, the buyer can return the unsold dresses at a later date at her cost and at her own risk. The final topic we'll cover in this chapter is risk of loss during breach of contract. We'll begin where the seller is the breaching party. If the seller breaches the contracts and fails to deliver the agreed upon goods, the buyer can either accept the goods as is, or two, reject the goods in whole or in part, subject to the seller curing the deficiency in the goods. Once goods have been delivered, the UCC provides that the buyer has a right to inspect them before acceptance. Now, this inspection must be performed in a reasonable time and manner. And if the goods fail to conform to the contract, the buyer can reject all of them, accept all of them, or accept some of them and reject the rest. They have to give the seller a reasonable right to cure, in other words, to come and provide conforming goods. Goods are considered conforming when they meet the contract's terms, and if the goods are not as described upon delivery, they may be considered non-conforming. If the buyer rejects the goods, the rejection must be within a reasonable time after delivery. The buyer may reject the goods if no cure is possible or if the seller fails to cure within a reasonable time. Upon rejection, the buyer must hold the goods with reasonable care for sufficient time so that the seller can remove them. If the seller does not give instructions on what the buyer should do with the goods after a reasonable time, the buyer may store the goods, reship them to the seller, or resell them. If the buyer resells the goods, the buyer may first reimburse itself for the cost that it paid for the goods, and in some cases, they can even get a commission for their sale. When the buyer has rejected the goods because they don't conform to the contract, the buyer can also recover from the seller, in addition to the purchase price, its cover damages, which are damages for having to obtain substitute goods. The risk of loss remains with the seller until the buyer accepts the goods or until the seller cures the deficiency by providing conforming goods. If there's no cure or the seller fails to cure, the buyer can revoke the contract. If the risk of loss would have transferred to the buyer had there not been a breach, then the risk transfers to the buyer to the extent of any insurance the buyer has. The risk of loss reverts to the seller after the buyer's insurance is exhausted. We'll end this session by discussing risk of loss during breach of contract when the buyer is the breaching party. Usually in sale of goods contracts, a buyer breaches a contract when the buyer fails to accept conforming goods. A buyer can also breach a contract by wrongfully returning goods or simply failing to pay for those goods. If the buyer fails to accept conforming goods and then the goods are lost or damaged under a shipment or origin contract, the risk of loss would have already transferred to the breaching buyer anyway. However, if the contract is a destination contract and the goods are lost or damaged after a breach, the risk of loss remains with the seller. but the risk of loss remains with the seller only until the seller's insurance is exhausted. If the seller does not have insurance or the loss exceeds the seller's insurance cap, the remainder of the loss shifts to the breaching buyer. When a buyer breaches, the seller can cancel the contract, withhold or not deliver goods, reclaim the goods, or resell the goods. The seller's remedies are designed to make him or her whole and get the benefit of the bargain as if the buyer had performed. They don't get a windfall under the UCC. Just as in the common law, the seller has a duty to mitigate damages to the extent they can reasonably do so. When a seller has conforming goods that the buyer wrongfully rejects or fails to pay for, they have to resell those goods if possible, as long as the goods are not custom like monogram shirts. The seller's damages are the difference in price under the contract, less what they were able to recover by selling them. Or the seller may recover damages as the difference between the contract price and the market price at the time the goods were intended for delivery, plus any consequential or incidental damages, for example, charges, expenses, and commissions, minus any savings from expenses not incurred. This is the end of Chapter 15.